So I'm Vanessa Zimmer, the one with the apparently bad internet connection. I am Zimmer Legal, and a lot of you on the webinar are my clients, or we've chatted before about working together. So I think you know sort of my deal. I'm a privacy and data protection lawyer, sole practitioner, and my co-host here is Lou Raban, a security guru.
Thanks, Vanessa. Yep, I'm the founder and CEO of Cyber Defense Group. We are a security and privacy consultancy, and we specialize mostly in cloud security and incident response. And we've done a lot of work together with Vanessa on privacy initiatives as well.
Yep. So we're excited to do this together. So we're going to jump right in. We're going to bust some myths here, like that old show. This have given you an idea of what it means to have implemented reasonable security. So our first myth is, we'll call it the myth of subjectivity. So there's a misperception that reasonable security is too subjective to define, and there are too many virgin legal standards followed. And the truth is, there's room for subjectivity, but it's not really subjective. There are actually very concrete resources for defining reasonableness. And when you look at FTC enforcement actions, which are summarized in their Start with Security video series, which I highly recommend that everyone look into, they're little video vignettes. And it's a lot easier and quicker than reading through decades of enforcement actions. So they've sort of sussed out everything into these little videos for you. But you see that the FTC wants to see that companies have a thoughtful information security program. And that means written policies and procedures, including an incident or data breach response plan. So they also want to see specific technical measures, and we're going to talk about some of these throughout this webinar. But I think another valuable resource that helps you meet these objective standards is the top 20 controls in the California Data Breach Report that came out in 2016, and that's sort of considered the gold standard of when we try to interpret reasonableness. So Lou, do you want to talk to those top 20 standards a bit?
Yeah, sure. Thanks, Vanessa. The top 20 is something SANS and the CIS, Center for Internet Security, have put out for many, many years, and it's really encouraging to see how the California Attorney General had brought these out and said, hey, these are the what we consider to be at least a base of what can be considered reasonable security. And what's challenging about that is we have an alphabet soup, obviously, in cybersecurity of standards. There's NIST, there's ISO, there's SOC 2, then there's the other industry-specific standards like PCI, HIPAA, et cetera. So it gets really confusing for an organization and even cybersecurity professionals and legal departments to say, okay, what do we conform to? What are we trying to do? So what's really interesting and great about the top 20 controls is that this is something where it's basic cyber hygiene. These are 20 controls that have been determined that if you're doing these things, you're probably going to be able to at least detect and respond to 90+% of the attacks that are out there. And on one of the pages, I think it's page 32 of the data breach report, they really distill these down into about 10, all of the 20 controls into about 10 categories, like counting your connections, controlling your users, et cetera. So what they've done is they've made it very accessible for anyone, even if you don't understand cybersecurity at all. You can really understand, okay, hey, are we doing these things? And you can hold people in your organization to task by asking them, how do we rate against these?
That's a really good point, that they're in plain language. So it's a great resource for lawyers. You're not going to speak the same technical jargon that someone like Lou does, but these top 20 controls are really written in plain language. So I think when we distribute the webinar materials afterwards, we can include a link to the data breach report. It's a pretty helpful resource. And I just realized we didn't launch the first Zoom poll. So we're gonna do 3 sort of fun Zoom polls. They're all gonna be anonymous, so you don't have to worry that we're going to know, who said what, but we just thought it would be a fun way to get engagement and sort of tailor the talk a little bit. So here is the first one. Do you feel you have an understanding of your legal obligations regarding information security and data protection? And we'll give you a few seconds.
Some results now. While we're waiting, it's really interesting also to understand that compliance is not security. And this is where I think a lot of organizations fall down too, where they say, hey, we've gotten audited against standard X, let's say SOC 2, and we passed an audit, or ISO 27001. How did we get breached? And I think that's another, strong point for the CIS top 20 controls, because that is not compliance. There is no certifying body that says you are compliant with these controls. You basically have to self-audit and determine if that's the case. And these controls are not an audit standard. You can make them into an audit standard internally, but they really are a different way to look at your environment versus, hey, we're compliant with ISO, et cetera.
That's a really good point. Okay, so I think we're going to move on. Do we have any sort of general breakdown from the Zoom results? I'm not seeing them on my screen. Oh, there we go. So about 67% said yes, and 33% said no. So you guys are already in pretty good shape, and hopefully by the end of this, we'll get 100%. Okay. So while there are many different legal regimes that deal with information security, their stance on security is relatively consistent. So GDPR Article 5 mentions security. It specifically mentions confidentiality and integrity. And then Article 32, even more explicitly, requires appropriate technical and organizational measures to ensure a level of security appropriate to the risk. So that's not prescriptive, meaning it doesn't tell you what is appropriate. That is up to all of us. CCPA is a bit more prescriptive in that it references encryption or redaction of personal data. And this is referenced in relation to the private right of action that consumers have for a data breach. So under section 1798.150, consumers and the Attorney General can bring an action if there is a breach of, and I'm quoting, non-encrypted or non-redacted personal information as a result of the failure to implement and maintain reasonable security procedures and practices appropriate to the nature of the information. So you can see the word appropriate in both of these regulations, meaning that you have to conduct your own risk assessment of what's appropriate given your environment, the kind of personal data that you process. So for example, if you're processing biometric data or special categories of data under the GDPR or payment card data, those are things that I think the appropriateness of the technical measure is going to be a little heightened. Whereas if you're just processing email addresses for the purpose of maybe sending a newsletter or the like, the security measures don't have to be at such a high level. And you see the same idea of risk and reasonableness with FTC standards. So FTC guidance is actually extremely prescriptive and very helpful to look at. So again, those start with security videos are great, but they have decades of guidance around specific measures that companies should be taking. And so, Lou, I'm going to pass it back to you to maybe talk about a few of those specific things that the FTC has found that it was unreasonable that a company was not doing them.
Yeah. One is a really interesting case where there was a company that was, saying that they were encrypting the data, and the data was actually more obfuscated. It was easily reversed. It was not a unique key. So all you had to do was take a default instance of that data, put it into a demo circumstance of this or instance of this software, and you would be able to decrypt all the data. And there was a dentist's office, for instance, that was breached that said, hey, patient information, because according to HIPAA standards, you did not have to disclose because it was encrypted, but it was actually not encrypted. So the FTC caught that and they find the organization for that. There's been a number of others. What is actually reasonable, and what is a process that would truly protect the data that you're a steward of or owning. And there's been a number of other cases like peer-to-peer file sharing, managing your vulnerabilities. As Vanessa stated, there's a huge compendium of FTC consent decrees and cases where they've caught companies not doing the right thing. I will say that obviously the modern world kind of, when you look at some of the revenue and the fines against that revenue for some of the larger organizations that are getting caught, I would say they probably need to be, I truly believe that there should be criminal penalties. I'm looking forward to the day when they actually do start to criminalize some of this.
No one on this call agrees with you, Lou.
Yeah, I'm sure. If you're looking for guidance, I can tell you for sure, the FTC site will give you a huge, if you're doing something and you're like, has this ever happened before? Could we get in trouble for it? I think the FTC probably has seen it and would have a case to reference that.
Yeah, and it's all in those videos, which are great. And I'm developing an information management course for USC's law school right now that I'll teach in January. And these videos have been great because I don't have to create my own instructional materials for those weeks. I can just give the students the links to these videos and tell them what the obligation is. But you'll also see things like SSL technology to protect transmissions of data in transit through websites. They want to see that you've got secure application development process in place, that you've got a process for secure destruction of personal data once it's no longer needed. And they also want to see, I think Lou mentioned vulnerability scanning, risk assessments. These are considered to be the most basic measures that companies need to be taking. And along those lines, they've also required businesses who have been found to be in violation of the reasonable security standard, they've required them to engage a qualified third-party professional to conduct an annual security risk assessment. So what we can take from this is that doing an in-house review is not the same as having a third party come in and vet you. And this isn't personal to IT or security. This is really true of anything. It's why if I build a privacy program for a client, I'm not the one coming in and auditing it for GDPR compliance the next year. It would be a totally different law firm or accounting firm or consulting firm. And the idea is, the person who establishes the program and the protocol maybe is not the most objective when it comes to evaluating it. So when it comes to information security, it's great if your in-house IT team tells you that there are no problems, that everything is set up in a secure way, that you don't need to worry. But as a lawyer, you should know, or as an operations person, even not necessarily a lawyer, you should know that that's not going to be viewed the same as actually having an objective third party come in and tell you whether they agree that everything's okay and that you've set things up for success. And then lastly, before we move on to the next myth, I wanted to point out that the FTC has also been very clear that aligning with the NIST standard, so one of the alphabet soups, is almost always going to set you up for success when it comes to security compliance. And the FTC has a video and a long blog post that explains why in great detail, and we can submit that with, or we can distribute that with these materials as well. It's another great resource that explains in pretty granular detail how you would make sure that you're meeting the standard that they want to see. So while they won't tell you, oh yes, if you're compliant with NIST, that means you'll never have a problem with the FTC, because to Lou's point, one doesn't equate with the other necessarily, and you can be compliant with NIST and still have something go wrong, have data mishandled. But by being compliant with the NIST standards and auditing against that compliance by a third party, you're probably going to be much less likely to ever have a problem. So we're going to go.
Yeah.
Oh, you go ahead.
Yeah. Sorry. Yeah. You want to launch the next poll for the cloud?
Yeah, that sounds great.
Right.
So the next myth is called the cloud myth. So this is the myth that because you use a lot of SaaS solutions, software as a security solutions, cloud vendors, that security obligations are sort of their problem and not necessarily yours. So how do you feel about that?
Also, I wanted to remind everyone that you can also ask questions in the chat, and we will have a Q&A section at the end to answer your questions.
Thank you for reminding me of that. I forgot to tell you that at the beginning. So we're going to make sure that we'll have room to answer all the questions at the end. So please do submit them via chat. Okay, so do we have any results for the cloud myth yet?
We have, we'll give 5 more seconds, so get your answers in, and I'll end the polling right now. And we're sharing those. So not sure is, yeah, which makes this next section very relevant.
Yeah, no, it's great. And I'm not surprised because vendors often intentionally are a little bit murky on this point too, especially when they're in the sales mode. But look to your contracts is where I'll start, because your contracts often say the opposite of what you might think they say. So logically, you would assume that if you're using a SaaS solution, a cloud solution, that security is baked into that product or service, and that it's something that you're paying for as part of your subscription fee, and that you're really not responsible for it. But when you look at the actual contracts, they often say the opposite, which is that you as the enterprise customer have ultimate responsibility for security. And sometimes it's limited to your implementation of the tool. So the vendor will carve out things that are within your control in terms of how you enable various security settings that they offer. But sometimes it is actually a broad disclaimer of any and all liability associated with the tool. And even I see this in tools that process personal data, and this is at the core of their business model. And so the salesperson might be selling you on this is a great secure way to outsource, insert function here, payroll, timekeeping, any number of functions that require personal data. But then when you get to the stage of looking at the contract, they're not sort of willing to put the weight of the company behind it in contractual obligations. And you should care about this a great deal because it results in risk for you. And the FTC has brought actions against numerous businesses for failing to vet the security posture of their vendors or partners with whom they share personal data. And the FTC has explicitly said in a blog post that they recently did that was 6 tips for secure cloud computing, that it doesn't mean you can outsource security. Personal data is still your responsibility, and I'm going to quote here, you still need to have a written data security program that lays out your company's process for securing consumers' personal information and people on your staff knowledgeable about maintaining, monitoring, testing, and updating that program. So that's a lot. They're still expecting you to essentially have an in-house IT person who is confident and knowledgeable enough in security matters to know that things have been implemented in a certain way, or if you don't, they're expecting you to seek that expertise out. So Lou, do you want to talk at a high level sort of about how businesses can implement cloud solutions in a secure way?
Yeah, I mean, it's a broad topic, but I'll try to be brief. One thing I will say is, especially based on the results of our poll, the shared security model is really relevant. And we get a lot of organizations that come out and when they approach us, they say, hey, we feel like we're pretty secure. Or they on their website, and Blackbaud, I think we might be speaking about them a bit later, but they're an example.
Yeah, you dive in.
Yeah, they were talking about how great their security was, et cetera, but they had no one dedicated to security. And a lot of companies, when they approach us, will say, well, what are you doing for security? And they'll say, hey, we're in AWS, they have SOC 2, they have ISO 27001. So we're just kind of absorbing that into our environment too. They think it's an umbrella protection, and it's absolutely not. So that's a huge red flag to anyone that's vetting you from an information security standpoint. And that's where a lot of organizations will come to us because they've never necessarily committed to security. They've done the minimum, or they've got a lot of security debt. They're kicking the proverbial can down the road. And so they come to us and say, oh my gosh, now we're doing business with Apple or Visa, et cetera, insert, Fortune 50 here. And they're asking us about all this stuff on our security. And a lot of times, if you're answering those big companies with something like, oh yeah, we have SOC 2 via Amazon, then what you're doing is you're showing them that you have absolutely no maturity in your program. So it's really important to get that together quickly. I've seen some real train wrecks of companies downloading policies from the internet and providing it as a third-party response. These are very disastrous ways to go. And you used to be able to get away with that, maybe even 5-10 years ago. But today, companies have become savvy. There's been way too many breaches, especially via third parties. So they expect you to actually, do something. So there is the governance, risk, and compliance part, which is what Vanessa was talking about, which is policies and procedures that you can demonstrate. But then there's also the operational part. And this is where we help a lot too, because initially we would come in and say, hey, here's your policy suite. Let us know how you're doing against that. And then we saw that our clients were falling down. They were like, okay, well, we can't even keep up with this. So that's where we moved into more of an operational implementation guidelines and help. So we actually provide engineers to help you. So you mentioned, Vanessa, not being able to outsource your security. What that means is you can't outsource your security to Amazon because you have this shared security model, but you can, and we do this for all of our clients. We are the security team. So, maybe that's a blind pitch for CDG, but we're not just saying us, anyone. It's just like privacy, a DPO and things like that. You don't have to have an internal person fulfilling that role. It can be an external resource, so just like security, but the things that you need to do are on the top 20, and I won't go into everything that you need to do, especially if you're a cloud reliant or cloud native company. It's a different model. There's stuff that you need to do, but you definitely need to make sure that the people, process, and technology around that are, you have some structure around that.
Yeah, that's a really good point. And what I've seen is that many of my clients, especially startups or smaller organizations that don't yet have a large IT function, let alone any security function, is they have a distributed responsibility model within the organization where business stakeholders or department leads are in charge of their own cloud tools. So in that scenario, the director of marketing would be the one who actually goes to Salesforce and negotiates the Salesforce contract and signs the contract, and then is responsible for the implementation and sort of ongoing maintenance of the tool. There's absolutely nothing wrong with this as long as those people are receiving training and they're capable of managing the tools. The problem that I see is that many of them, most of them are not. I'm not blaming them. They're busy doing marketing. They're busy, doing customer acquisition. They're busy running a company. So it's a lot to put on your business stakeholders to have this distributed responsibility model, because they're not going to be able to look at logs every day, and they're not going to be able to necessarily understand why multi-factor authentication is important. But the centralized model where IT manages all your tools and you have an IT owner of each system like Salesforce, that's not going to be feasible from a financial standpoint for most companies either. So I think you do have to find that middle ground where you're pulling in expertise as needed, whether that's on the security side, like the legal privacy side, like me or anybody else. But it's really important that if you have this distributed responsibility model, that you're providing training to the employees who are responsible for systems. And that's something that I know Lou has done. It's something that I've even done for the more basic things where it really is just about keeping default settings and making sure that people understand, oh, I'm the one that actually has to go look at the logs and see who's accessed this system, because there's nobody else doing it for the company. It really is that business stakeholder. And Lou mentioned Blackbaud too, which is a really good example. They're a vendor. I got 2 different breach notifications from them because 2 different organizations that I donated to use them. And I think they are a great example of everything's great until it's not. You can sort of look like you've got your act together, but then if you don't, eventually it sort of comes to light. And we'll talk about that myth in a
Vanessa, we've lost your audio again.
Can you hear me now?
Yes, there you go. You're back.
Okay, I'm back. I'm back.
Uh,
We jump into our myth about small, medium enterprise.
yes. Sorry, you're cutting in and out again, Vanessa. Did you want to launch the poll?
Yes.
Okay, let's launch it. So this poll is about being comfortable with the strategy and resources that are applied to data protection at your organization. And we understand that for many people here, perhaps you're not in charge of that function, but this is still a relevant vote because it's important to understand what's your perception as well of how important security is to your organization. And remember, this is anonymous, so you can be honest.
Can you hear me now, or am I still?
Loud and clear.
Okay, great. Alrighty.
We'll give about 15 more seconds. We're getting some more responses in. Okay, I'll close polling. So it looks like most people are, 71%, that's pretty good.
Yeah, that's great. We do have a lot of our mutual clients on this.
Yeah.
So.
If you're, yeah, one of our clients, we hope that you said yes.
So this next myth is that security only matters if you're a big company. And you hear this a lot at conferences and things that, well, I don't need to worry about it. I'm not Facebook, I'm not Microsoft, I'm not LinkedIn. And look, there is a certain truth to that. They are bigger targets. But when you look at the regulatory picture, you really see that's not true, and that being an SME can actually make you an easier target than companies with million-dollar legal and regulatory lobbying budgets. And so when you look at GDPR enforcement, it's been underway for over 2 years with some pretty substantial fines. And you see the things that you would expect, which are huge fines against huge companies. So British Airways was fined over 200 million euro, Marriott over 100 million euro, Google 50 million euro in France, 7 million in Sweden. But you also see a lot of fines against smaller players. And I mean, a lot of the lawyers on the webinar probably know regulatory bodies, they need those big fines to fund the small ones. So all you need is one British Airways fine, and now you've got a few years of runway to go after all of the SMEs. So they have to do a few big fines to keep funding their departments, but their bread and butter are really these smaller actions. Why? Because they're easier for them. You don't have the resources to fight and go to court and negotiate a long settlement. You're much more likely to just say, okay, fine, we admit it, we were wrong, we'll pay the fine, let's move on. So you're not immune from regulatory scrutiny. And when we look at GDPR enforcement actions by the type of violation, the most popular is an insufficient legal basis for processing. So basically, you shouldn't even have the data to begin with. It's unnecessary, improper collection of personal data. But a close second are Article 32 violations, where insufficient security practices, and there's been a data breach or an unauthorized handling, some mishap as a result of that Article 32 violation. And in FTC enforcement, we see the same pattern. Big fines from big companies that fund their ability to go after the smaller players. And I've looked at a lot of these in detail again as I put together that law course, and I was really surprised to see, as I was going through them in detail, how many data breaches that the FTC has pursued that involve a few thousand people or even less than 1,000 individuals. So these are not necessarily target size or Wawa size breaches where millions of people were affected. It could be as little as 600, 700, 1,000 people. All it takes is complaints. So enforcement is complaint-based. So even if you're a small business, you could be the subject of an inquiry if enough of your consumers have complained about you. And that's something where, as a lawyer, it's hard for me to advise as to the risk of that because I'm not in that consumer's mind. I don't know how much of a bee they're going to have in their bonnet about an issue they've had with you. But it is, I think, in this age of social media, pretty safe to assume that if you have a security issue, someone's going to complain about it publicly, and perhaps that makes its way to a regulator. And I know, side story, but one of my mentors is a former regulator, and she said that it has happened before where the FTC has been notified of a data breach because they are the consumer victim of one. So an actual regulator is receiving a notice in the mail saying your personal data has been breached. That obviously gets them a little interested. And then we're going to talk briefly about CCPA, because I know that's on everybody's mind and it is in the title of the webinar. I wish I had more to tell you about enforcement, but little is known still. Inquiry letters are private, much like an FTC civil investigative demand, so they're not published. We don't know who they went to or what they say, but we do know that they were sent. And we know that the CCPA grants consumers a private right of action for data breaches. We know that there's a 30-day cure period before they can actually sue for statutory damages, and that they have to give businesses notice of this cure period and the opportunity to cure. And I'm going to talk about this, or punt to Lou to talk about that in a minute, as to whether it's even possible to cure a security violation in 30 days. But we know that this sort of consumer right of action exists, and we know the Attorney General can bring actions against businesses for any other violations of the CCPA, not just data breaches. But again, the extent and type of enforcement sort of remains to be seen. There's a lot of rumors, and we can piece certain things together. The Deputy Attorney General for Privacy Enforcement said that they did send letters on July 1st to a number of companies, and that those were at least in part based on consumer complaints. They seem to have been focused more on notice issues and do not sell issues. So basically, has your privacy policy included all the information that it should include under CCPA, or have you offered the right to opt out of a sale if a sale is occurring? They don't seem to have been focused on security issues, but we don't really know for sure, because again, these letters are private. And the Deputy Attorney General has said that they're currently enforcing the parts of the actual statute that are clear and should be heeded. I think that's an important thing to recognize, because the data breach provision of the statute have never been in doubt. That pretty uncontroversial in terms of how they have been interpreted. And they're really the lowest hanging fruit, I think, in terms of enforcement, because if you've got a security issue, you've got a data breach, it's a little more cut and dry for the Attorney General to pursue than whether you're selling personal data or not, which is a whole other series of webinars that we could do.
Yeah, Vanessa, if I could jump in just about previously the SME myth about being too small. I mean, from the beginning of doing cybersecurity, I remember even 20 plus years ago, when we would go into a company and they would say, well, we're not Fort Knox. I can't tell you how many times I've heard that, and it's no longer at all, if it hasn't become apparent to everyone how important cybersecurity is. I mean, it's an existential threat to one's business, to an organization. And therefore, besides all of the regulatory actions, which is the point of this webinar, it really is a matter of, if you want to be around in 5 or 10 years, you really need to start, dedicating some of your revenue to protecting your environment. And then also to your point about the cure, the 30-day cure, when we do incident response, we have plenty of stories about how the investigation alone takes over 30 days most of the time. And there are some other points with GDPR, that 72-hour notification period. That's really, really interesting. And we can get creative, with counsel and outside counsel with how we're going to determine an incident versus an event. And that's usually how we try to get around it, with saying, an event is not an incident until it's been declared an incident, which, after a thorough investigation. But still, it's a little bit unreasonable to consider, hey, in 72 hours or even 30 days, not only will you understand what happened, but you'll be able to fix it. The but I do understand why they've put that in place, because otherwise companies would either not obviously declare at all, or if they did, they might wait 6 months to a year to say, hey, that happened so long ago, it's not really an issue anymore.
And on my end, so I've turned my video off.
There you go. We can hear you now. Good.
Okay, great. Yeah, I've turned the video off. Hopefully that will help. So we don't know yet how the 30-day cure period will actually work in practice when it comes.
We lost your audio again, Vanessa. Okay, we can see your video, but we can't hear you. We can hear you now.
Okay, great. Sorry, guys. This is just frustrating. So we don't know how the 30-day period will work in practice, but we can guess that it's not going to work particularly well if this is the first time that you're thinking about these kinds of security issues. And so I would advise against taking a sort of let it ride mentality where you think, okay, well, we've got this 30-day period. We're not subject to GDPR. Let's just wait and see if we ever have a problem. That's not something that I think either Lou or I would advise doing.
Not at all.
Yeah, and so this ties to our second to last myth, which is the myth that no one will ever know if you've had unreasonable security practices unless you've reported a data breach. But avoiding a legal obligation to report a data breach really doesn't mean that you've gotten away with it, right, Lou?
Yeah, well, and I think we've all hopefully learned from the lesson of Uber, where it was very obvious that the chief information security officer was trying to kind of sweep things under the rug, and had gone so far as to really try to cover up that there was a breach. And now there are, if I remember correctly, there are some criminal penalties for that. Is that correct, Vanessa?
Yeah, it's pretty insane. I don't know that I've ever seen anything like this, but the San Francisco, I think it's the U.S. Attorney's Office, had the former CISO arrested, and he's been charged with 2 felonies for not disclosing the 2016 data breach when he was being interviewed by investigators regarding a separate data breach that Uber had had. So he, I guess, perjured himself. He lied and covered up this prior stuff, which is, it's not great, but he wasn't the only one involved with this whole sort of weaving a story around their prior incident, and apparently their chief legal person in charge of security issues at the time was involved as well, and sort of put the legal stamp of approval on calling what was really a breach, on calling it a bug bounty, or we paid a security consultant. I think you have some opinions on that, Lou, even aside from the criminal issues, but just what's the effect of paying someone? Let's say you've got a ransomware issue, or you're thinking about a bug bounty program. What are your thoughts on that?
Yeah, well, 2 different things. I mean, listen, with paying ransom, we are diametrically opposed to paying ransomware. Now, a lot of people will say, well, it's a business decision, and if you can get away with it, and yeah, I get it. If you're the CEO of an organization and it's a matter of your business is going to fold, or you pay a couple $100,000 to get it back, I understand why you would make that. I do not agree. What you're doing is you're funding criminal activity. I think that this should be illegal to pay these ransoms. And the other thing, if you feel bad for these people that get hit with ransomware, I would say when you look at most of these environments, I'm not saying that ransomware can be stopped 100%, but you can limit the damage, and you can also have proper backups to restore from backup. A lot of companies that are paying these ransoms don't have either of those things. So I would say, rather than feeling bad for them, I would say, that's Darwinism. That's business Darwinism, saying, you did not invest in a proper security program. You did not invest in having proper backups, and therefore this is what happens when you do that. And the other point with companies not really talking about data breaches, you don't know most of the data breaches. If it's handled correctly, you won't hear about it. So you really need to commit to a program and understand that when you're reading in the news, when you're reading about these breaches, you're hearing about probably 10% of the breaches that are actually happening. What was the second part of that, Vanessa? You had said about
bug bounty programs.
Oh yeah, the bug bounty program. Be careful. We've run into situations with clients where we've spoken to them about bug bounties. One time, someone just jumped into it and said, "Wow, looks good. Let's put it up there." And then they had, you know, there are offshore people that are offshore, and not just offshore now. Now with, you know, obviously COVID. There's a lot of people that are freelancing. They've been laid off, but they have security skills. So as a matter of fact, I know a lot of security professionals right now that in their spare time, especially if they've been furloughed or laid off, they're crunching against bug bounties. If you don't have a proper bug bounty in place, I don't recommend you put something up saying, hey, hack us and we'll figure it out, because that could lead to, you're basically attracting the attention of anyone in the world that wants to hack your environment. And if you're not prepared to handle that, you've got people also, the people that are looking at these bug bounties, some things are not necessarily a bug bounty. If I can go to your site and do a denial of service with one of your forms, that's not necessarily a bug. That's something you should put your defense in depth strategy in place, but that's not a bug in your code. And that's the other problem with bug bounties is they're a good thing to have, but you have to have a structured approach. That's really my point.
Okay, interesting. The other thing that's sort of similar with this idea of, you know, the internet is watching is a lot of plaintiffs' firms are now getting wise to the fact that they need technologists to look for these things. So there are a few really big ones, one in Chicago, and I'm not a plaintiff's lawyer, you know, so they're sort of the bane of my existence. As I'm building a program for clients, I'm trying to make it plaintiff lawyer proof, but I have a lot of admiration for basically that they've seen that it pays to understand the technology or to get someone involved who does in the legal process, because you know, I'm obviously, me or no other lawyer is going to be out there, you know, scanning the dark web looking for instances of breaches, but there are technologists that work for plaintiffs' law firms who do that, and then they can figure out sort of in a backward way who may have had an incident, who's vulnerable, who may be violating even certain legal standards. So Illinois has this Biometric Data Act. If they can find biometric data that's been breached on the dark web, then that suggests that you're collecting it in the first place. And then they go look at your notices and your consents and they see, are you compliant in that way? So just because you didn't report a breach publicly doesn't mean that no one will ever find out. There are a lot of different ways that someone may find out. It could be years from now, but there could still be fallout. So avoiding that breach in the first place is really what you want to do.
Yeah, that's the 21st century, you know, example of ambulance chasing.
Yeah, exactly. Yeah. Yeah. And the last myth is for all the lawyers and operational executives who are in attendance, it's the myth that security isn't really your concern and that it belongs to IT. And there's this sentiment that you hear among some lawyers that, look, it's really their vertical. I'll be in the room, but it's up to them to make it happen. And that just doesn't work in practice. You know, someone has to take the lead in ensuring accountability. And so the question might be, well, why you? Why a lawyer? And I think for me, it's that as lawyers, we have a really unique position. We can counsel. It's privileged and confidential when we counsel. So that helps, that it's protecting the things that the company you know, wants to stay confidential when these discussions occur. But also as lawyers, we usually have a seat at the executive table that's required in order to bring all of these things together, in order to, you know, hire a security expert, to do vulnerability assessments. All of these things require money, which requires approval of executives. And generally lawyers can sort of raise the hand up and get the attention of the people who matter, who can open the purse strings in that way. And then even separate from that side, you know, you have an obligation, a fiduciary, or, you know, our obligation as lawyers to be clear with our clients about legal standards and to be clear about the consequences of not meeting those. And look, the FTC, they're not expecting you as a lawyer to know everything about data security, but they're expecting you to know what you don't know. So they're expecting you to identify potential gaps, to say, who's looking at this? You know, are we monitoring logs? What's going on with that? And then if the answer to that question is nothing is going on with that, they're expecting you to raise that up the ladder and engage an expert or someone who will be responsible for that. So as a lawyer, you're really uniquely positioned to make the corporation accountable for information security and, of course, privacy issues as well. And that's really all I think all we have for our STEP presentation. We wanted to leave time for questions. Did we get any questions? Let's see.
Please put your questions in the chat and we'll be happy to address them.
Yeah, is that in? Let's see. I don't see any. When I'm teaching, I always take that as a sign that I'm just the most fabulous professor on the planet. Not that people were multitasking and didn't find it engaging. Okay, see there's a Q&A and a chat window, but we're getting crickets on both.
We've been obviously very clear during this webinar, or yeah, I think there are CLEs to be you know, collected at the end of this too. So, and
on that point, for the CLE, I'm going to distribute the certificate of attendance and the evaluation form that are required by the State Bar of California. We'll distribute those with the webinar materials later today and the links that we talked about. And then it's approved for California CLE, so that's not a problem. But if you're a lawyer in another jurisdiction, you may still be able to submit it for CLE. It's just an extra process sometimes where you want to make sure you're saving that certificate so that if they're ever, you know, looking for proof of compliance, you can show them that it was approved in another jurisdiction and apply for approval in your jurisdiction.
You'll probably get a CPE from IAPP or from any of the other professional organizations too, I imagine. What do you think, Vanessa?
No, I think maybe I would have had to have done that ahead of time as opposed to...
Oh, maybe, okay, not just attending. We'll have to look at their policy. I just put mine in recently, so.
Yeah, I think probably not, since I didn't talk to them about it. It would have been a good idea to do, but.
Didn't you say that people don't get CLEs if they don't ask a question too?
No. Yeah.
Great. Well, if there's no questions, I think we probably can conclude.
Yeah, I think so. I mean, I hope everybody found it informative and that you come away with some clear resources for how to evaluate reasonable security. And again, we'll include those links, which I think they are worth going through and sitting down with your colleagues if they're not on the webinar, really, and just kind of checking and seeing what your posture is internally and whether it makes sense to start thinking about doing a risk assessment or having a third party take a look at that.
Yeah, absolutely. Again, having someone look over what's happening, especially if you're not exactly sure, depending on what your organization looks like from an information security standpoint. If you're, looking at your IT people to cover security as well, that can be a bit of a conflict sometimes, because IT's job is to keep things up and running, whereas security, we have that as well. We want availability to be there, but we have other considerations such as confidentiality and integrity of the data that IT doesn't always look after. So it is a really good idea to reach out to a third party to have them assess you and really determine where you are, because as I stated earlier too, the organizations that are going to survive in the next 5-10 years and beyond are the ones that have a proper privacy and security strategy.
Yeah, definitely. Alrighty, well, I guess we'll sign off and thank you all for attending. It was great, and I apologize for the technical issues on my end, but I guess this is just the new world order. When we all work from home, we just got to roll with it.
Right. Thanks, everyone.
Bye.